everyone, welcome back to my channel. So for today's video, we're going to dive into a landmark Supreme Court case in the Philippines. This is Chavez v. Gonzalez, GR number 168338, February 15, 2008. This case raises important issues about the application of RA 4200, the anti-wiretapping law, and the limits of government regulation when it comes to free speech and freedom of the press. We will cover what the case is all about, the facts, the main legal issues, the ruling of the Supreme Court, the ruling, and my takeaways learning from the decision. So let's get started! So, number one is, what is the case all about? At its core, Chavez v. Gonzalez is a constitutional challenge against warnings and threats by government officials to media organization not to broadcast or air alleged wiretap conversations. Specifically, the infamous Hello Garci tapes allegedly involving a sitting president. The government, through the Secretary of Justice and the regulatory body, the National Telecommunications Communication or the NTC, threatened media outlets that airing these tapes could make them liable under RA 4200, the anti-wiretapping law. The petitioner, Francisco Chavez, filed a petition for a certiorari and prohibition, asking the Supreme Court to nullify those warnings and issue directives preventing further acts that would curtail press freedom and the public's right to information. Thus, the case sits at the intersection of RA 4200's protection of the privacy of communication and the constitutional guarantee of freedom of speech and of the press. Number 2. Facts of the case. Here are the relevant facts. In June 2005, there were reports that a wiretap conversation involving the president and a Comelec official would be released. That so-called Hello Garci tapes. A complete version and allegedly doctored version were made known. On June 8, 2005, the Secretary of Justice publicly warned that individuals and media entities who possess or air the tapes could be held liable under RA 4200. On June 11, 2005, the NTC issued a fair warning to radio and television stations to observe the anti-wiretapping law and refrain from airing the tapes. A dialogue was held with media organizations represented by the Kapisanan ng mga Broadcasters sa Pilipinas or the KBP on June 14, 2005. Afterwards, the NTC and KBP issued a joint press statement claiming that no formal order or circular restriction press freedom had been issued. Nonetheless, these public warnings had a chilling effect. Media outlets became wary of airing the tapes for fear of criminal or administrative liability under RA 4200. In response, petitioner Francisco Chavez filed a petition under Rule 65 of the Rules of the Court, seeking to nullify the statements and warning as violative of freedom of expression, press freedom, and the public's right to information. Next one is the issue in the case. The main legal issue before the court was whether the warnings and public statements by the Secretary of Justice and NTC, cautioning media not to air the wiretap conversation, amounted to an unconstitutional prior restraint on freedom of speech and of the press. Other connected issues included the applicability of RA 4200, to such media broadcasts whether the threatened application of the anti-wiretapping law justified just restraint. The standard of judicial review applicable to content-based restraints on speech. Example is the whether the clear and the present danger test or other tests should be applied. Whether the fact that the government statements were not formal orders or circulars but mere statements affect the analysis. Example is a press release warning, still a form of act sufficient or prior restraint. Number 4 is the ruling of the Supreme Court. The Supreme Court granted the petition. It ruled that the warnings or the public statements by the government official constituent unconstitutional prior restraint on freedom of speech and of the press. The court reaffirmed that restraints on free speech or press should be subject to strict scrutiny when they are content-based. In this case, the government failed to meet the high standard required under the clear and the present danger test. Specifically, the court found out that the reliability of the tape was questionable. There were different versions, one complete, one altered. The identity of the speaker was unclear, and the evidence relating to how the wiretapping was done, by whom, under what circumstance, was ambiguous. Because the government failed to show a clear and present danger from broadcast, the threatened application of RA 4200 did not justify prior restraint. The fact that the warnings came in the form of public statements, not formal circulars, did not make them any less valid as acts of prior restraint. The court stressed that act does not require formalization into official orders. What matters is that the statements were made in official capacity and had chilling effect on media. The result was the writs of certiorari and prohibition were issued, nullifying the June 8 and June 11, 2005 statements by the Secretary of Justice and NTC, respectively. And my takeaways or my learning about this, from this case, a few key lessons emerge. Even laws protecting privacy like RA 4200 have limits when weighed against constitutional freedoms. RA 4200 prohibits unauthorized wiretapping, a legitimate aim, but cannot be used as a blanket justification for suppressing speech and press, particularly on matters of public interest. Prior restraint, even by mere warnings or press statements, is a serious matter. Government must be careful. Censorship does not only come in formal orders. A public warning by an official can have the same chilling effect, which courts will not tolerate if the threshold for danger is not met. The clear and present danger test remains vital in safeguarding free expression. Content-based restraints must pass strict scrutiny, and the mere potential of a law being violated does not suffice to suppress speech. Public interest and the right to information can override government's desire for secrecy or control when alleged communications involves matters of high public concern. The example, possible corruption, abuse, and accountability. The public's right to know is of paramount importance. Judicial review plays a crucial role in balancing conflicting rights and interests. The court's willingness to brush aside technicalities of procedure. Example, the petitioner lacks of direct standing. underscores that protecting constitutional rights, especially those concerning public interest, must sometimes transcend procedural hurdles. The ruling in Chavez v. Gonzalez remains a landmark affirmation of press freedom and the public's right to information. Even in the face of laws protecting privacy and prohibiting wiretapping, the clarifies that government cannot use the threat of RA 4200 to muzzle media, especially not through mere warnings or public pronouncements. If you found this helpful, please like this video, subscribe for more jurisprudence breakdowns, and let me know in the comments what you think, especially about the balance between privacy laws and press freedom. That's all for today. Thank you for watching.